There are certain special circumstances in which the release of grand jury records is appropriate, and even outside the boundaries of the rules, which say that you cannot give these records out no matter what. Ultra secret. Complete proposed redacted set of Epstein and Maxwell grand jury transcripts, and a description of any other Epstein and Maxwell grand jury materials, including exhibits. It's like, great, just put that in a Dropbox for us. If historical interest in a case has persisted over a number of years, that's a pretty important indicator that we're not letting it go. Big updates from the Department of Justice in both of these cases. The Maxwell and the Epstein case both got new filings. You see memorandums in support by the USA apparently came skidding in last night like at 11:59. People were watching the docket, and that was the deadline. And so we got now the memo that has come out from the Trump Justice Department in an effort to unseal the filings in both cases. Now, this filing was submitted in both cases, substantively the same thing. You see, it's the Jeffrey Epstein and the Ghislaine Maxwell case. This is the government's response to the court's orders, where the judges came back down, and we did a prior video on this where the judges just said, fill this out, essentially. Give us more details on this because it's pretty bare bones. So this is coming in from J. Clayton, right? So he works under, it's Pamela as the AG, Todd Blanche, the deputy AG. Todd Blanche is the guy who went and met with Ghislaine in the prison. And so under him is J. Clayton. J. Clayton's going to be the author of this, and a little bit more about J. Clayton, which is interesting, is that Trump has nominated this guy a couple times to a couple different things. So he's been around a while, but he's also a Bill Barr protege, which is curious. On January 4th, President-elect Trump announced this guy, this U.S. Attorney Clayton, to be the SEC chairman, and he was nominated on Inauguration Day, and then the Senate voted him in, and he was sworn in and became the chairman. Then after the SEC, he went out and worked at the Apollo Global Management Board, right? Lead independent director on the board. So he's like a finance guy, right? SEC, finance guy. Then he rejoined Sullivan and Cromwell, became a senior policy advisor, independent board of directors, and all of these things. Like, this dude is super accomplished. He's done a bunch. He's consulting. He's getting $500,000 a year for some sort of consulting fee, and has been the chairman of the SEC, all these things. Like, what is he doing as a U.S. attorney prosecutor for the Southern District of New York? Oh, well, it's the Southern District of New York, baby. That's Wall Street. You know how much money's there? You know how much power this dude and leverage this dude has based on his connections with Apollo Global Management and all these things? So in March, Clayton joined as an independent member of a board, and then this last was selected on November 14th, 2024 by Trump to be the U.S. attorney for the Southern District of New York, right? So he came in. He's a finance dude. Now, prior to that, on June 19th, 2020, so nearing the end of Trump's term, Biden's about to come in, Attorney General Bill Barr, you remember him, who said Epstein killed himself like 5 minutes after it happened, saying that Trump would nominate Clayton to replace Jeffrey Berman. Okay, there was another U.S. attorney there, this guy, and he was kind of fired / resigned. Remember, after Epstein died, about a year went by, and then Bill Barr came out and said, Jeffrey Berman is no longer here leading this district. What? And he wrote another response. He said, yes, I am. You can't fire me. And then Trump ultimately had to come in and settle the squabble, and he did. He came back and then ultimately fired Berman. And Berman then went and worked for some private firm, wrote a book about it, and he then was theoretically going to be replaced with this guy back then, June 9, 2020. So it sounds like Clayton then, he was going to replace Berman. However, he was not selected. They went with Audrey Strauss. She became acting. And then Clayton resumed his path to the role when Trump announced he would be the interim U.S. attorney for Manhattan. Now he's going to assume the role officially pending confirmation by the U.S. Senate. So pretty interesting. They're finance people. Clayton's wife, Gretchen, whom he started dating while they attended the same Pennsylvania high school, worked at Goldman Sachs. Clayton's wife resigned from her job prior to the confirmation. Yeah, because Goldman Sachs is in the Southern District of New York. So pretty interesting prosecutor for them to put on this case, and to have him filing this. We'll see if there's anything more that comes of it, but that's him, J. Clayton, and yeah, this guy right here is what he looks like. Assumed office, now he's over there and been around a while. So he sent this one in for both the Ghislaine and the Epstein cases. He said, all right, the government respectfully submits this memo. I know, Judge, that you told us you wanted additional information. Here we are. Responding to your court's orders concerning the two pending motions that we filed to unseal these grand jury transcripts, one in the Epstein case, one in the Maxwell case, prosecuted right here in the Southern District of New York. This memo, as directed by the court, you told us to do this, addresses the specific facts and factors highlighted in the court's orders relevant to the particular grand jury materials that are at issue here, in order to ensure that, quote, transparency in this process not be at the expense of the government's obligation to protect the victims, right? There's rules about about that. And the government also requests leave to file a supplemental submission. Okay, once the government and the court have received any filings from the victims or others referenced in the transcripts. And if there's 1,000 victims and there's a possibility that a good portion of those are in the grand jury transcripts or proceedings, then that might take some time. And so we might see this beefed up down the line. But here is what the Trump DOJ says from J. Clayton. As the court recognized, the Second Circuit has held that, quote, there are certain special circumstances in which the release of grand jury records is appropriate, and even outside the boundaries of the rules, which say that you cannot give these records out no matter what. Ultra secret. Saying there was this case, this judge called C.J. Friendly said something like, well, there are certain special circumstances in which release of grand jury records is appropriate, even outside the boundaries of the rules. The Second Circuit enumerated a list of non-exhaustive factors for trial courts to consider when deciding these motions. Now, they gave us these factors, these indicia, these little check boxes you got to go through and analyze and measure them, put them on a little scale, balance the scale out, see where does it go. Does it favor disclosure or does it favor continual seal? The identity of the party seeking disclosure, who wants it? Well, it's the DOJ. That's a pretty big one. The DOJ wants it on behalf of the American people, okay? President Trump directed his attorney general to go do it. So it's big. Like, there's a lot of weight to that factor, so you should unseal it. Whether the defendant to the grand jury proceeding or the government opposes the disclosure, no, they don't. So we can put some check boxes over here. We'll just tally that up. So we got 2 over here, and over here is going to be the seal side, so on the right side. Grand jury proceeding, does the government oppose it? No. Does Maxwell oppose it? We haven't seen anything yet. Number 3, why disclosure is being sought in the particular case? And that's a great question, right? So maybe you want to put that one in the middle. We would say we have a right to transparency. We've got questions about the performance of our judges and prosecutors and FBI agents and all the people who were responsible for this investigation, which seemingly was bizarre. In fact, it's not even seemingly, it's bizarre. He got a non-prosecution agreement that was like a blanket umbrella for everything until it wasn't, and he was allowed to operate hanging out with the most powerful people in the world for decades. So disclosure is for accountability, right? It's to make sure that there is actually justice, to make sure that the system is not completely corrupted and broken, covering up a global PDF file ring. So that's a pretty big why. Now, on the other hand, they would just say, well, it's for your prurient interests. You're just interested in sex and disgusting behavior and all these different things, which obviously we're not. We actually want to stop that stuff from happening, which is why we're so interested in it. But they might just say, you know, it's just tabloid material. It's just salacious. And there's nothing really there that is legitimate for the public to have, which is maybe what they'll say. But we got another factor for what specific information is being sought. So we want everything, the entire files. And that's a big ask generally. Well, okay, so it's not narrowly focused. No, we want everything. How long ago the grand jury proceedings took place, which was not that long ago, actually. You know, it was, we're putting these out. We got 1, so we'll put number 2, we'll put in the middle, or that's a 3. What specific information is being sought? That's a lot, so I would say that I'm going to put that in the negative camp. How long ago did they take place? And we'll put that kind of in the middle camp because they're not that old, but Epstein's dead. The current status of the principals of the grand jury proceedings and their families. Okay, we don't know about that, so that's also kind of in the middle, I'd say. We don't really know, go either way. The extent to which the desired material, either permissibly or impermissibly, has been previously made public, and we don't know. We don't know what's in it, right? So we don't know what they've got that we don't have. I presume it's a lot. So if it is already made public, then you would not get it because you already got it. And so since it's not public already, I'm going to put that of disclosure. The extent to which the desired material either has been previously made public and whether witnesses to the grand jury proceedings who might be affected are still alive. That does not go for us, right? There's probably a ton of witnesses who are still alive because these cases are pretty fresh. The additional need for maintaining secrecy in the particular case in question. And as far as we know, there's really no other reason for there to be secrets, unless it's something that's pretty problematic, like our intelligence agencies are behind it, or Mossad or foreign intelligence agencies were colluding in this operation. So on July 22nd, the court directed Trump's DOJ to file a memo of law addressing with specificity these and other factors the government views as germane to its application. The court also directed the government to state whether, before filing the instant motion, counsel for the government reviewed the grand jury transcripts, like did you read anything, is there anything even useful in there, and whether the government provided notice to the victims of the motion to unseal. Now, and to submit, they want indices of the grand jury materials, a brief summary, the number of pages and dates, a complete set of the grand jury transcripts, complete proposed redacted set of Epstein and Maxwell grand jury transcripts, and a description of any other Epstein and Maxwell grand jury materials, including exhibits. It's like, great, just put that in a Dropbox for us. Just put the link link on there. Google Drive, I'll host it. I got extra space, no problem. Just let me know. Happy to help. So it would be pretty easy to just share all of that, We'll see what the judge does. Now, here is what the DOJ says in response to the factors. Now, the court directed the government to address the factors. What follows is a discussion of each of the factors, which are designed to assist the court. You asked to have some help creating some careful judgment about your decisions, Judge, and so we're going to help you figure that out and balance the interests around public disclosure and public interest. Now, the first factor is about the identity of the party seeking disclosure. So who is ultimately the one requesting it? The DOJ. The first factor considers which party is seeking disclosure. The identity. It carries great weight. Here, it's the government. They want grand jury transcripts, and it's consistent with increasing calls for additional disclosures, okay? It's the public, and here's this press release. So it's not just the public, it's also Congress, which is unfortunately a little bit more powerful than the people. But Chairman Comer issued a subpoena for Maxwell and then said she's not going to get immunity, so that subpoena is now basically trashed. I mean, she'll show up, but she'll just invoke the fifth repeatedly. The government's position serves as a preliminary indication that the need for secrecy is not especially strong. Like, the government's not worried about it, so we can unseal it, even if it's not dispositive. Now, government support cannot confer disclosure. Like, the government can't say, well, we approve it, so judge, do it. But not objecting is a big deal. The second factor asks whether the defendant or the government opposes public disclosure. This was a big question. What's Gouveia going to say? Because if you're Gouveia, if you're her defense attorneys, you say she's probably got a strong interest in keeping herself as the sole source of information. Okay, so she should object to these disclosures, because if these disclosures are made public, it means we need less of her. Now, we'll see. A defendant's opposition to public disclosure is also not dispositive, and we haven't heard from her. Yeah. Maxwell has indicated that she expects to craft a response and set out her position to the court. Okay, so we'll see. Now, Epstein is dead, probably. So he can't have a position, they say, except being 6 feet under, maybe. Where is he? Do anyone know? The third factor considers why disclosure is being sought here. The Second Circuit said, well, it's entirely conceivable that in some situations, historical or public interest alone could justify the release. It's possible. As described above in the underlying motions, there is undoubtedly a clearly expressed interest from the public, all right, and Ghislaine Maxwell's crimes. Beyond that, there is abundant public interest in the investigative work conducted by the DOJ into those crimes. And so, as noted, we have not received any outreach from any of Epstein's surviving family, right? So they haven't contacted us. Nobody's saying, don't go after this. Everything seems like it's pretty quiet out there. Now, attention given to Epstein and Maxwell has recently intensified in the wake of the July 6 memo, the other J6 memo, announcing the conclusion of the review into Epstein and Maxwell. And yeah, it caused this whole thing to explode, that 2-page unsigned memo. The instant motions for unsealing are consistent with the fundamental purposes set forth in that memo, given the magnitude and the abhorrence of his crimes, to provide information to the public while remaining sensitive to protecting the rights of the victims. Now, fourth factor. The fourth factor asks what specific information they want disclosed. Here, the government wants the transcripts of the Epstein and Maxwell cases and exhibits as well, and all the filings as well. As stated in the motions, any public disclosure granted by the court would be subject to appropriate redactions of victim-related and other personal information. So, like, you want that to be everything. Like, we want all the boxes. Sometimes you call them the grand jury transcripts, but you're getting all of the evidence. So we want to be careful with those words and see what they're actually going to get us. Like, are they just going to release, like, the only document that was the transcribed document? That's it? No exhibits, nothing else? Probably. Here, how long ago the grand jury proceedings took place? Not that old. June and July, and then June and July of 2020. So Epstein 19, Maxwell's 20. Here, the passage of time has not dulled the public's interest in these cases. No, it has not. If historical interest in a case has persisted over a number of years, that's a pretty important indicator that we're not letting it go. Now, the current status of the principals and their families. The sixth factor. What is the current status of everybody who is involved in the Maxwell-Epstein grand juries? The passage of time brings about the death. That brings about the death of others. Should matter, but it might create vulnerabilities. And so in this case, the grand jury testimony was offered specifically in connection with charges against Epstein and Maxwell. Epstein's dead. No family member has even come to the government saying they have any interest in these motions at all. One of Epstein's family members previously filed a request for materials pursuant to FOIA, but we responded. No litigation happened. Maxwell currently is incarcerated, and no family member has approached the government indicating an interest in any of these motions. And Robert Maxwell, her father, had a bunch of kids. Several of them died, some of them in weird situations. But, a brother might say, well, Maxwell talked about me and about how I also got abused by our father or something. And so if that comes out, then that would be devastating to me and my reputation, and I had nothing to do with this, so I'm an innocent party. And so I'm just going object because there's going to be some spillover. We'll see. But nobody's said anything thus far. Sounds pretty quiet. The extent to which the desired material, either permissibly or impermissibly, has already been made public, the government is not aware of the relevant grand jury transcripts ever being impermissibly leaked. Certain aspects and subject matters of the transcript became public during the Maxwell trial, which we covered at length, to the extent that any of the desired material was disclosed to Maxwell as a result of the disclosure obligations. It was disclosed pursuant to a protective order. Now, many of the victims whose accounts related to Epstein and Maxwell that were subject also testified at trial, and it was consistent with the accounts of FBI agents and detectives from New York PD. And it was factual. A lot of that was used in civil litigation too. Now, the government is providing under seal a list of witnesses whose accounts were conveyed in the grand jury proceedings. I wonder who is on that list. Noting which witnesses testified at trial too. The eighth factor is whether witnesses to the grand jury proceedings are still alive. Here, there was one witness, an FBI agent, during the Epstein grand jury proceedings. One guy. There were two witnesses, the same FBI agent from the Epstein grand jury proceedings and a detective with the New York Police Department task force with child exploitation during the grand jury proceedings. Both witnesses are still alive. So one person worked on both cases plus another one. The FBI agent continues to be an agent with the FBI, still available, and the detective continues to be a detective as well as a task force officer. And so, consistent with all the rules, we are including statements of others who are still alive. In the sealed submission accompanying this filing, we'll know which victims are still alive. And finally, the final factor says the additional need for maintaining secrecy. Is this like a national security catch-all somewhere? In addition to the typical reasons for grand jury secrecy, the grand jury transcripts contain victim-related and other personal identifying info about third parties, which might be involved but were not charged, to which the government is sensitive, and which is why we want to redact the transcripts before releasing them. Now, the court directed the government to state whether, so if you think there's going to be names in there, like any names at all, there are not going to be a single name in there that we don't already know. The court directed the government to state whether, before filing the instant motion, counsel for the government reviewed the Maxwell grand jury transcripts. Before filing this, we did review the transcripts. The government has provided notice to all but one of the victims who were referenced. The government has attempted to contact the remaining victim but can't find her. In addition, the government is in the process of providing notice to others. And so the court directed us to submit a bunch of things: indices of the materials, number of pages and more, the complete set of all the transcripts, complete proposed redacted set of the grand jury transcripts, a description of any other materials, right? So that's kind of what we're talking about, including but not limited to exhibits. So when they're referencing transcripts, it's the transcript. That's it. As to the final category, the government provides a description of all the underlying materials presented to the grand jury, as well as copies of and proposed redactions to certain materials. So we're submitting all of these ex parte, not showing the other side, and giving it to you under seal. So the public's not going to see it, the other side's not going to see it, and you get to do what you want with it. The government underscores that it takes very seriously its obligation to protect victims and believes the redactions not only are appropriate, but are necessary to protect those rights. All right, so that came out from Jay Clayton, U.S. attorney over there in the Southern District of New York, in a 10-pager, bunch of supplements, bunch of materials got transferred over. We'll see where it goes